So one soap case is about 12 to 13 grams. So the minimum a person will carry is about one soap case. The maximum can be an entire consignment of 10 kg. Imagine if it is one soap case at a time and there is 10 kg of drug available on the other side, how many soap cases are available? Okay, this is a huge number of soap cases available. Imagine if everybody is carrying 100 soap cases at a time, even then there are 10 carriers available, only from transit from the border into India. Again from the border it's the same thing. If 10 people are carrying 100 soap cases each, all of them can carry 100 each to Dimapur and beyond, or each one of them can split it into multiple people at every transit point. How many transit points are there? We are not aware. It depends on each and individual case how many transit points are there. It could be the same person bringing to Guwahati. It could be one person from, say, Myanmar bringing it to the bordering village. For example, it's More or Bijang or Molcham in, I'm just giving few names. It's not necessarily these, but these names have come up to a notice. On the Indo-Myanmar border, from there one person just brings it either to Imphal or Bishnupur or Rukhrul. From there the next person brings it to Senapati or Kangpopi. From there another one brings it to Kohima or brings it to Guwahati. So there are multiple combinations which are possible, which makes things extremely difficult for us to handle. However, that does not mean that the link cannot be traced back to the original suppliers or the bulk people along the border or in Myanmar. But the problem is not all link will always have a soap case or a drug with him. If I am on the border in Myanmar and I am having 100 soap cases and I have sold all 100, whether it is to one person or to 10 people, when the police come and pick me up, I have nothing. Okay, I do not have anything with me so that you can prove that I am involved. The only proof is what? Either a communication intercept or his mobile forensics or statements of witnesses or call data records or statements of other co-accused. Okay, that does not make his crime any less. All of them are relevant evidences. However, everybody thinks, well, everybody in the sense, although we in the police we are sometimes convinced that it is the proper trail to lead, but somehow on the other side of the fence, which is with the judiciary and the prosecution, this is not taken, I would say, on face value. Dhuranai to saman dhuranai to. Do you think that if nothing is recovered from him, he is not involved? Okay, you see it is not involved because nothing is seized from him. You may say that there is nothing with him, so he is not involved. Okay, so that is regarding the seizure part. How about the other parts of the NDPS Act which none of us thinks, especially my friends in the prosecution and some probably in the judiciary. No, I am not trying to pinpoint fingers, but this is a session when I am supposed to give my view on the challenges being faced. So I am giving the challenges that we face. Okay. So how about import interstate, export interstate, financing, transportation? These are separate offenses. Each one of these terms is a separate offense. If I am able to tell the court saying that XYZ is involved and I need a warrant of arrest against him, believe me, no police officer in Nagaland has the history of planting any evidence like this. Okay, you are all from Nagaland, whether it is the judicial officers or the prosecution officers. Nagaland police does not till yet have a history of planting any evidence on anyone. So if we are saying that this person is involved either in the transportation or financing, we'll give you decent proof. Everybody, like this fellow will always come up with saying, oh, if someone has paid 5 lakh rupees, his source of income is none. There is one statement that I have brought, say 25 soap cases from him. There is enough to prove from his call records, from the statements of the witnesses, and the bank statements that the transaction has taken place. My request is not for myself, not for the police, for the well-being of the society in general, not only in Nagaland, but throughout the country, that please try to assign some value and credence to it. We will be doing a great disservice to the society if we are not doing it. Honestly, we will not bring you anyone who is innocent. Some of the lawyer friends may feel bad, okay, that you may be, there are no lawyers probably here except the prosecution or the judicial officers. Some of the lawyers may feel bad that they are not getting enough business for the bail matters. It is true, because persons who are not involved, we are discharging them on our own. Okay, so we don't want to do it also. We don't want to pick up innocents, but there is a problem. Okay, so honestly, when we are bringing a person with say 100 soap cases or 10 soap cases or 1 soap case, that one person is probably the last person in the link that we have been able to pick up with the seizure. All others are also involved in different capacities or even in the same capacity where we have not been able to intercept them. Someone has carried 100 soap cases to Dimapur, dropped it at my house, and I give it to him and he is caught. That doesn't mean that I am not involved. I am involved. It's only that I was not caught with a drug. Okay? That doesn't mean that I have not committed an offense. This brings me to the other aspect. Each of these acts involving drug trafficking are separate acts. They are separate offenses. I am personally of the view that we need to register separate FIRs for each of these. Okay, even if there is a drug seized or not seized, we can register a separate offense. There is a transportation is an offense, financing is an offense. We need to register cases against this. This is a method of making things and life difficult for the traffickers, for saving the society. Please bear with us, my friends in the prosecution and in the judiciary. We will not be able to produce soap cases always. But we will be able to produce, wherever we are not able to produce soap cases or drug, we will be able to produce decent evidence that the person is involved. Okay? I'll draw an analogy for this. Another aspect of this, a person has been involved, we've got many of them in the past year and a half. A person has been involved in transportation and trafficking of drugs through Nagaland, I will say. Not into Nagaland, through Nagaland. It may be into Nagaland or Nagaland is a transit, through Nagaland, maybe 20 times in a year. This gentleman that we caught, all of you are aware, in Nagaland, I don't think any police officer or any judicial officer is not aware, Baharuddin. At least 25 occasions he has trafficked in the last 1 year. Even when we caught him, we did not catch anything. We did not seize any drug from him. Does that absolve him of the offenses that 25 times that he had transported the drug through Nagaland? Does it mean that he is not involved? So if you think he is not involved or there is no evidence, okay, then the analogy that I draw is this: a person has committed 20 murders, serial murders, one after the other, gets arrested only in one case. What will you do? Will you not investigate the other 20 offenses? I think an honest answer, a commonsensical answer from any one of us will be yes. He has committed 20 murders. So the same thing, wherever we get evidence, where we can follow up on the transportation also, we will register cases. So it's not always that we will be able to produce soap cases. We will not be, but we will be able to substantiate it. So I have given 20 soap cases to him. He's given out of 25 to that gentleman, 5 to this lady. We have a trail of evidence where if we catch him, through his statement and investigation and other things, we'll be able to check whether these consignments have reached the others. This is a menace which has to be tackled at a different level. So my request is, please give due consideration to this. Uh, Another issue is bail. As the law stands today, there is a law of default bail. I am not against that. Whether it is a default bail or bail based on a exercise of your subjective satisfaction on any ground, I will not intrude into that. I don't think enough time is given to police or the prosecution to reply to a bail petition in a number of cases. If we were to be given an opportunity, we would probably try to convince the court why a person may not be released, or if there is a dire necessity of his being released, then how we can ensure that he, within the confines of the law, does not tamper with evidence or witnesses or doesn't engage in any crime per se, and on the other hand does not subvert the legal process by either disobeying you, which means that if there is a condition put that he has to present himself in the court every 10 days, 15 days or 1 month, that he should be present there, or coming to the police station once a week or once a month, he should come there, or that before the grant of the bail, if it is on medical grounds, can we not tell the state government to bear entire expenses for his treatment? With the central schemes and the Nagaland government scheme, the CMHIS, everybody who is a resident of Nagaland is entitled to free treatment at government appellate hospitals. Although it goes without saying that it is available to the jail inmates, anyone in judicial custody, but we've sought a clarification from the state government that they will be provided free treatment at the government cost, even if it is in AIIMS or if it is in, say, New York in some specialized hospital. Because these are flimsy grounds on which people will apply for bail and get away because saying that hospital facility theek na hai. Okay, please have due consideration for it. Judicial office, again, I'm not saying anything against any judicial officers or prosecution. Please don't misunderstand me. I'm just giving you my part of the story. It takes a lot of effort and it's a lot of risk involved in catching a criminal. Okay, once a person goes out on bail and he is not traceable and not available to us, the amount of dent that it creates in the law enforcement agencies is almost unimaginable. It just breaks the back of the law enforcement agencies. Iman kam korigena dorishe. Olai jale ki hobo. Olaishe. Obo charibi next time na doribo. And this is a part of the reason which propels crime in the society. Okay, again, I'm giving you my point of view as a police administrator. Legally, there may be 101 things that you follow the procedure and all those things. I'll come to those also. So on bail, my request to my friends from the judiciary and prosecution officers is, we have tried to streamline certain things and procedures within the police. We have issued guidelines and instructions to them on how the bail petitions have to be opposed. We have also given them a set of sort of checklist sort of points that if, as I said, we are not going to intrude into your domain and say don't grant bail. It is your subjective satisfaction, you want to grant bail, but please ensure, please request, my request is ensure that the person is available to us. Okay, we have given them, circulated them a set of checklist of points on if the concerned judicial officer wants to grant bail, please request them that some of these following conditions, if they can be put, it will be good. I will not go into details of any court individual officers. Please, if I give examples, firstly, I will not take names. If I'm giving example, it is not against an individual or a court or an officer. It is to cite an example. One particular case when our officer said, Sabitu Khan pra ekta, panchta, amakhan ke tu dishe, Itu Khan pra tinta charta point bandi divi na. He will come to the police station once a week or court, or we should be allowed to verify his place of residence. Normally, one of the conditions that the court would put is he will not leave the jurisdiction of the court. 99% of the cases, the accused person after granting bail has left the jurisdiction of the court. It is not an affront to the police, it is an affront to the court. Amma Khan laga important, Amma Khan laga ego to chhadi na, Abani Khan laga alo, ijat rakhi na. Honest, I'm giving a very, very honest, dispassionate view. Please don't take it otherwise. Otherwise, this doesn't make any sense for me to talk, okay? There have been umpteen number of cases where people have absconded are not available at all. There have been numerous cases where they have gone out and started indulging in doing the same thing again and again. How do you handle this? Please allow us to have the liberty of verifying where he will stay post grant of bail, that he will come to the court or the police station regularly, his attendance will be marked. Let us cooperate and develop an app or a system where if he has to report either to the police or to the judge or to the court, say once a while, that periodicity may be different. His attendance should be properly recorded by a fingerprint or a biometric or something in the court premises. This is all doable. These are all things which are doable, and it's not for me. It is for all of us. So when I am, as I said, we have issued some guidelines and some checklist of points. We can keep adding to it. Okay? I am not ordering the court. In one of the cases when we said, Amma Khan ke liye order diya, said, this is what the feedback I got. Please, my request, my humble clarification is, we are not ordering the court. We are just telling our officers, please request the court for doing this. Okay, so my request is, please, we want our officers to make written representations, give us enough time, if it is a regular bail petition, for the prosecution, for our prosecutors. Honestly, I've met a lot of you personally. My request is, if we oppose it, if we oppose a bail, don't go beyond the brief of which the police is requesting, that you have to oppose bail. Amma Khan to kobo bail na dibi ta. Hobo dile bhi ho. Please don't do this. It's a family, you know. The whole criminal justice system is a family. The whole criminal justice system is a family. I do my work, you don't do it, the family falls apart. You do your job and the jail doesn't do the work properly, the family falls apart. It is like this. Okay, it's not for individual accolades that we are in a system. We are there for a job to protect the society from a menace, at least in this case. So, I am open to the guidelines or the checklist that we have issued at our end to be shared informally or formally through whatever channels with the judicial officers and with the prosecutors. These are not orders to you, please. These are just requests from us that give us these opportunities so that we can jointly fight the menace. Okay. Then in the morning session, the presumption aspect was discussed very clearly. I also mentioned it during my short speech in the morning. I may be a law graduate, but I have not been a practicing lawyer or a judge, so I'm not aware of too many of these provisions, but a commonsensical approach is, dead of the night, there is one vehicle with 2 people coming, 10 soap cases, and the police intercepts. So who has done it? Either one of them have done it or both have done it. Or the police officer has planted it. So no, where is the chance of getting a magistrate? And some of you probably have been lawyers. You know, honestly, if I was a defense counsel, I will throw all evidence to shreds in no time. Any evidence, howsoever scientific it is, in no time. अच्छा किमान बजे धोरी छे 12 बजे धोरी छे ठीक है ओके जीडी एंट्री किमान बजे आसे होई छे कहानी मैजिस्ट्रेट के किमान बजे माते छे कहानी हो गया खत्म 3-4 सवाल में एवरीथिंग इज गॉन यू नो इट्स yes you have to follow a process na justice moitra will give you what are the common problems okay but these common problems cannot be solved on hindsight they have to be solved there where do you get a person we have been requesting for immediately on stopping a vehicle we have been requesting for magistrates or officers for witnesses we don't get in the dead of the night we don't get after 4 o'clock what do you do do you think that police officers are untrustworthy so if the police officers cannot be trusted then the males will not have wives and the ladies will not have husbands if they are police officers. It's as simple as that. You ought to trust a police officer at least on some value. The law may not trust it, but what he's writing and what he's doing, if it is trustworthy, please start trusting that. Unfortunately, this is a vestige from the past. The whole logic is that this person can put a person anyone under threat and coercion and extract a statement. I will not deny that Nagaland police doesn't do it. Yes, in some cases, these extra legal means are required, and I will not justify what is happening. But if it is I will say if it is not permitted within a limit, and the whole system does not stand together, then we are looking at extrajudicial means of tackling justice, which could be even worse. So I will not even say that a balance has to be maintained, but a a slightly better than zero tolerance should be tolerated. I'm not saying zero tolerance, I say slightly better than zero, maybe 1% can be tolerated. It all happens. It happens in the families, even with our own children and kids. I don't think anyone who is a father or a mother here has not slapped his child even once. It happens in the family, so it's not for anything which is bad. It is for preventing a general menace in the society. Another thing is the appreciation of technical evidence, which I would put into two parts. One is the forensic evidence part of it. Nagaland police current capabilities are okay, not very good, whether it is in NDPS cases or in other cases. We've just got some machines, so we are slightly better now. Earlier it was the samples and the chemical analysis was taking up to years because we were sending them to Imphal or Guwahati or to Gujarat or wherever, and it was taking years. Now we are slightly better off. There are certain things about technical evidence that you all know, but I thought it is my duty to just reiterate that there are certain aspects of chemical analysis which will always yield the same result if the same process is followed. 2 + 2 will always be 4. Okay, whichever machine or something is used, it will always be 4. Whether I use that machine, if I add 2 + 2, it will be 4. If Mr. Ajungba adds 2 + 2, it will always be 4. So the new law, the BNSS, has tried to factor that in, that the expert who is giving his opinion will be taken at face value, basically. Okay, but I think scientific evidence, forensic evidence has to be taken at face value. Second is the scientific or the technical evidence, which is, I would say, divided into two parts. One is my police officer friends know, others I don't know whether you've seen it. Most of you know the CDRs of the accused or the suspects. Most of these CDRs, 100% of these CDRs are antedated, which means if I ask a CDR today, it is for a date before today and not after that. These are all system-generated reports which cannot be manipulated by anyone. So if I have to talk to Mr. Kezo 20 times, it is 20 times. If I have talked to Mr. Ajungba 100 times, it is 100 times. It may not show the content of the talk, but it is the frequency of the talk which matters. It cannot be manipulated, okay? A similar is the case with the financial records from the banks or the financial institutions. Those are also antedated records which are called for. If I have sent 1 lakh rupees to Madam Azzi 1 year back, it will show 1 lakh rupees. It will not show 99,000 rupees. It has to be consumed on face value. If we are able to say we are able to interpolate other evidence saying that this fellow, say I called Mr. Ajungba at say 3:10 and say, Paisa, I'll send you 1 lakh rupees. After that, I have an incoming SMS, he has an outgoing SMS, and the bank account reflects 1 lakh rupees. You know, it may not be a conclusive proof, but it is definite circumstantial evidence which cannot be manipulated by anyone, whether it is the CDRs or the bank statements. So please, my request is, try to think and manipulate, not manipulate, and sort of take that evidence at slightly more than the face value which you may have been doing in the past. I can actually go on, but I think I would stop. This is, please pardon me, it is not against anyone. It is to help the entire system. With my own officers and staff, तैखन के तो अलग परा गाली दिए, दिवो परे ना अपने खान की गाली दिया तो ना पारे बोले भी अपने खान के रिक्वेस्ट आज ही करो बोले चांस पाइसे. Please try to appreciate our problems and the views that we are taking. Just one small thing that last I will say. I'll give you an example. Moitra Sahab, I don't know what is your opinion, but still. There were a lot of cases where drugs were being taken from Manipur to Dimapur and other places. And we knew from, say, analysis of the call records and all that these people XYZ are involved. Okay? If we try to intercept them, stop them, we probably get nothing. Most of the time, 99 times out of 100 or say 60 times out of 100 will not get anything. So I told my officers, I said, let's register cases under attempt to commit offenses and preparation to commit offenses. It took me 6 months to make them agree that this should be done. They were not willing to do it. 6 months down the line, we again sat down. By that time, we had developed decent information about the criminals. And they themselves said, Sir, attempt laga koribo na ki. We registered cases under attempt, and we are all aware that an attempt can actually be later on converted into an offense, commission of an offense. Even if it is not converted into an offense per se, attempt itself is an offense. The clinching thing that I told them was, I have not enacted the NDPS Act. It is the Parliament of the country which has enacted this Act, and in the Act itself, preparation to commit offenses and attempt to commit offenses are separate offenses per se. Okay, so my request is, this is uncharted thing for all of us. There may be a few instances where we will register cases under attempt to commit offenses and preparation to commit offenses. I give you a word that it will not be a false. It is based on certain information which we may not be at that point able to disclose to the court in the FIR, but there is definite information and evidence that we have. For example, it's a source information, I would not be able to tell more. So Mr. Kezo knows a lot more than me on certain things like this. How the source information is developed, it can take months together, 5 months, 6 months together. So I personally feel that registration of a case under even an attempt or a preparation gives us a very sound legal footing to work on other things. You know, if I don't register a case, I cannot call witnesses or summon witnesses or others. But if I register an FIR, even if it is of an attempt, I can work around in a legal process. So my request is, in the end, it's a huge problem Nagaland is facing. This 30% figure of Nagaland having a 30% incidence came out of a misinterpretation of what I had said about 3 years back. I will just tell you what it is. That time I was DG prisons, and the 30% of inmates in the prisons were either addicts or in NDPS cases. So I had said that if that is reflected into the society, the incidence of drug abuse in the society could be as high as 30%. Okay, that is what I had said, but everybody said, 30% ase. Hami tu kowa na hoy de. There is a difference between what I said and what people interpreted it. But even if it is not 30%, and if it is just 5%, imagine 5% out of a small population of 22 lakh in Nagaland. It is a huge number. It is a huge number. It is not a small number. We need to all put our heads together, join our hands together, without obviously compromising on the sanctity of the legal principles to combat this menace. Thank you very much.
It's a rare privilege when we are getting almost all the stakeholders relating to the administration of justice as regards NDPS Act. We all know that NDPS, narcotic drugs and psychotropic substance cases, has become a menace not only in Nagaland, in almost all the adjoining states too. And the learned DGP Nagaland is right in saying that it has been made a corridor through which the drugs are sent to everywhere in the country. Of course, other corridors are also there, but it is one of the corridors. Now the question is, why I am saying that it is a rare privilege? Because every time I had the opportunity on many occasions to interact with our officers relating to this act, and we are hearing that no evidence cases. Most of the cases are without evidence. Public prosecutors will say a little different way, and the investigating officers who are doing the works at the ground level, they have also their different say. Had there been the forensic experts also present here, that would have been added to this. The question is, when we are sitting together, of course there should be coordination amongst all the stakeholders. But at the same time, NDPS Act, you know that this is a special act and it overrides the provisions of CRPC and other acts. So when there is a specific provision has been laid down, stringent provisions have been laid down under this act, as far as it is practicable, this is to be followed. Otherwise, even if the lower courts give conviction or anything, that will be set aside by the High Court or the Supreme Court. That is one thing. Now, before going into the aspects, I have brought a small PPT because the books are not available everywhere. So, for your perusal, immediate perusal, I am showing. Let us start from our officers, judicial officers. Now, this is the provision for bail. It says, notwithstanding anything contained in the Code of Criminal Procedure, so the provisions relating to the Code of Criminal Procedure cannot affect the provisions, specific provisions laid down here under section 37(1). And three sections, section 19, section 24 and section 27A. Along with this, all the offences relating to commercial quantity, these will come under the scanner of this provision of 37(1). And the law has prescribed that without giving an opportunity to oppose the application of bail, without giving an opportunity to the public prosecutor to oppose the application for such release on bail, no court shall grant any bail. So if there is any violation on our part in this regard, that is without giving opportunity to the public prosecutor to oppose, if any bail is granted as regards these and these provisions, section 19, section 24, section 27A, and all offences relating to commercial quantity, if bail was granted, that was wrong. Secondly, when the public prosecutor opposes the application, court must be satisfied that there are reasonable grounds for believing that he is not guilty of such offence. First provision, he is not guilty of such offence. In other cases, under other acts, you will find the provision is different. CRPC provision is different. Nowhere it says the court must believe that he is not guilty of such offence. Rather, the law says that innocence of the accused. Court will presume, unless proved, the court will always presume the innocence of the accused. This is a special provision where it says that unless the court believes that he is not guilty of such offence, court cannot grant bail. The second one, that he is not likely to commit any offence while on bail. This is more difficult to decide that court must. Now, regarding statutory period of detention, unlike other acts, you know that 60 and 90. 60, up to 10 years it is 60, above 10 years it is 90. 10 years and more, it is 90 days. Now, here, if it is under these three provisions, 19, 24 and 27A, and all offences of commercial quantity, so in that case, it is 180 days, not 90, 180 days. So, bail will not be granted, default bail cannot be granted before 180 days in cases of all commercial quantities. And proviso says, if it is not possible to complete the investigation within the said period of 180 days, this statutory period of detention can be extended up to 1 year. But when this will be extended? On the report of the public prosecutor, not on the report of the investigating officer. Lawmakers made it specific on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. So, public prosecutors must submit an application. The investigating officers, of course, how the public prosecutor will submit the report. So, if the investigating officers approach the public prosecutors to submit an application along with the report of the status of the investigation and why more time is required for investigation of the case, then the court, on being satisfied, can extend the date up to 1 year. So, 365 days. I think in any case of commercial quantity, 1 year should not be taken for investigation. One more thing the public prosecutors must know, that this application is to be submitted before completion of 180 days, even 1 day before. So, before completion of 180 days, if the investigating officers consider that more time is required, they are to approach the public prosecutors to submit an application before the court before completion of these 180 days, along with the status report of investigation and why more time is required, what more is required for your investigation. Then the court will consider the same after hearing the public prosecutor, and even if there is an illegal aid counsel or defense counsel hearing both the sides, the court may extend the date up to 365 days. So, if it is not complied, then the accused person will be entitled to get the default bail after 180 days. Now, satisfaction part. Reasonable grounds for believing that the accused is not guilty to commit any offence while on bail. Both the conditions are to be satisfied. Not that one condition has been satisfied, so I am granting him bail. No, that cannot be. Both the conditions, both the satisfactions must be there, not one. If both the satisfactions are there, then only bail can be granted in cases of these offences. And reasonable grounds, the word used, reasonable grounds for belief. And while discussing this point of reasonable grounds, Supreme Court on various occasions said that it is something more than the prima facie case, prima facie ground. It is not that prima facie ground to believe that he is not guilty. It connotes substantial probable causes for believing that the accused is not guilty of the offence charged, and reasonable belief contemplated in turn points to existence of such facts and circumstances as are sufficient. So, court must consider, and court must, if the court wants to decide to grant bail, then satisfaction on what ground? There should be, court should record. It is not that, like other cases, medically ill, as learned DGP said, that cannot be a ground for release, particularly under these provisions. Unless even the medical board said that there is no provision for treatment. That too you can grant bail for temporary period, not permanent, unless you are satisfied that he is not guilty of offence, or and the satisfaction that he will not commit such offence in future. And this is in CRPC also provides for bail, and this is in addition to the provisions made in the CRPC 437 or 439 for granting of bail. And under 37 NDPS Act, it is the accused. In other cases, if any commercial quantity is recovered from an accused, in other cases, what happens? That law provides, CRPC provides, that the public prosecutor or the investigating officer must show the status of the investigation and must show that that there are sufficient ground not to release. But here it is the accused who must show the existence of grounds for the belief that he is not guilty, or to satisfy the condition precedent and leave the embargo on the power of granting of bail. This is in addition or contradiction to the provision of CRPC. Here the accused person must show that there is that he is not guilty. I have all the case laws relating to this. If the judicial officers need, I will give the citations later on. Now regarding small quantity, you know that in a case of small quantity, the total punishment can be extended up to imprisonment for 1 year, not more than that. CRPC says that up to 2 years or more, up to 2 years or more, it will be bailable. But here it is only 1 year. And had it been the section 37 is also applicable, then of course it would have been non-bailable. But section 37 is applicable particularly to 3 sections of the NDPS Act and all the offences under commercial quantity. So, in case of small quantity, it is not applicable. And since the punishment is only 1 year, our High Court, at least in 2 cases, stated that it is bailable. Specifically, in the last decision in bail application 473 of 2023, it is specifically observed that it is bailable. It is bailable. So now, since the judiciary is a disciplined organization, it is expected that when High Court has said it in a particular way, all the officers under this High Court, they will decide the same in a same manner. So it will be bailable, unless it is overruled by a larger bench of the High Court or by the Supreme Court. Now next, I want to come under section 41, 42 and 43 of the NDPS Act. Exactly I do not know regarding the investigation part of Nagaland. But in Assam, we have seen many loopholes during the process of investigation regarding these three sections. Now, law says that it is a special law. So it says that there should be statutory, these provisions, substantial compliance of these provisions, particularly section 42, part 42 subsection 2. Now what section 41 says, 41 subsection 1 says, the investigating officers, if they want to enter into the house, building, for making search or arrest of a person at night, they can obtain an order, obtain a warrant, search warrant from the magistrate. No qualification has been made regarding this word magistrate. Even search warrant can be obtained from the executive magistrate. So nearest magistrate, you can approach the nearest magistrate to issue the search warrant for entering. That is section 41.1. Section 41.2, it says that 41.2 says that any gazetted officer, any officer of the gazetted rank in the police force or in other paramilitary, etc., these forces, if he is a gazetted officer, he can also proceed without obtaining any warrant. But what is the requirement? If any information comes to him, he is to reduce it in writing. Maybe from his own information, he has reason to believe. Maybe from personal knowledge or information given by any person, and it should be taken in writing. If he is a gazetted officer, there is no bar that he need not obtain any authorization or warrant from magistrate. He can himself proceed because he is an officer of the gazetted rank. He can proceed for search or arrest. Now, when he has chosen not to go in person, maybe an officer of the DSP rank, he may have chosen that I will not go. Instead, he can issue authorization letter to any of his subordinate officer. Any of his subordinate officer. And probably it is assistant inspector of Assistant Sub Inspector of Police. In Assam, even an Assistant Sub Inspector of Police can do the search and seizure under NDPS Act, not below that rank. So, he can authorize any subordinate officer under him to go to the place to do the search and seizure. But that authorization must be proved, that he has authorized. That must be proved. There lies some falsity. In Assam, we have seen generally many of the police stations, the officer in charge of the police station is of the gazetted rank, inspector rank. So, he can himself go or authorize someone. He takes down the note in the GD entry book. He takes down the note. But authorization letter is not used, not issued, or I don't know, maybe subsequently it is issued. Recently I have gone through a case record where the police submitted in the FIR submitted by the search and seizing officer. There he mentioned that being a sub-inspector of police, I am empowered under 42. I am empowered under section 42 to do the search and seizure. I need no authorization. That is also written in the FIR. But at the time of adducing evidence, he proved one authorization letter. He proved one authorization letter issued by the officer in charge who had noted down the GD entry. Neither that officer in charge was examined before the court, nor the authorization letter has been proved. Why not proved? That authorization letter, particular authorization, has a separate GD entry, not the GD entry which was noted down as regards the particular offence. So, whether it will be proved. So, now again I am coming to that. Now, if the gazetted officer himself proceeds to do the search and seizure under 41, or if he authorizes someone subordinate to him to do the search and seizure, that particular officer will have all the power under section 100 CRPC and 165 CRPC. All the powers he will have. But that authorization must be there, particularly in some cases. If the, again I am repeating, if the information was received by the gazetted officer himself. If it is received by the gazetted officer himself, he must authorize someone if he decides not to go himself. Now, 42 is a little different. 42 says the information was received by the sub-inspector, not that gazetted officer. It was received by the sub-inspector himself. Then, sub-inspector in Assam also an empowered officer, probably in Nagaland also they are empowered officer to do the search and seizure under NDPS Act. So, a sub-inspector, if a sub-inspector receives the information, not the officer of gazetted rank, then he can, he must reduce it to writing. Reduce it to writing, and he may proceed to do the search and seizure. No bar, no authorization is required in respect of a gazetted, in respect of a sub-inspector when he himself receives the information. But one embargo is there, one requirement is there, he must reduce it in writing. Now, second part, subsection 2. Subsection 2 says that information must be sent to his superior within 72 hours. To his superior within 72 hours, that is one requirement for cross check by the court. So, that is to be proved before the court. Now, one situation is there. If the search is to be made at night, after sunset and before sunrise, proviso part says that if the search and seizure is to be made after sunset and before sunrise, then he must obtain an authorization from his superior. After receiving the information, before proceeding, he must obtain an authorization from his superior officer that he empowering him to go. That is one requirement. But there is also there may also be a situation that I have received the information now that the accused persons assembled in a particular house for dealing with or trading narcotic drugs. I have to move immediately. So, there is no time to obtain any authorization from the senior. No time. In that scenario, after reducing it writing, he can proceed immediately. Proceed immediately, but that is a particular situation that he has no time, and his note must say that I had no time. I had no time to take the authorization. Now, in a case I dealt with where the information was received in the morning at 7 o'clock, that there may be a truck will come from Dimapur side to Guwahati. They will cross Guwahati around 8 p.m. and police went there. He received the information in the morning. He was sitting idle all the day. He knew that it is to be at night. He is to stop the vehicle. He is to do the search and seizure at night. But knowing the same, he remained idle for the whole day and proceeded there at night. Maybe many reasons, maybe. But sufficient time was there. Sufficient time was there. 12 hours time was there to take the authorization from his senior. Does it show that he doesn't believe even his senior? That he even was afraid to inform his senior? That cannot be. So, time is a constraint. If you are to do the search and seizure at night without taking authorization, then you must prove that there was no time to obtain such authorization. And if there was any time to obtain such authorization, he must obtain such authorization, and this provision is mandatory. Other part may not be mandatory. Other part may not be mandatory, but at night, if the sub-inspector receives the information and proceed to do the search and seizure without authorization, that part is mandatory. He is to obtain authorization if there is any time. That part is mandatory, not the other part. And in that case, he is to send the report that reduced to writing, etc. He is to send the report to his superior under section 42, subsection 2, within 72 hours. That 72 hours is also to be proved. So everything is to be proved. This part is mandatory, so it is to be proved. Now another situation I am coming. (43) public place. Suppose a patrolling party. Patrolling duty, you are regularly you give the patrolling duty. During patrolling party gets an information that one drug peddler is dealing with drugs at railway station point. For that reason, no authorization is required because it is a public place, not a private place. It is a public place. But at the same time, different judgments said that if you want to enter the vehicle for doing the search, that if it is not a public bus or public vehicle, then it may be private. If there is time, you have to take permission, you have to take authorization. So on this point, many important judgments of the Supreme Court came during entire period till date it is coming. Constitutional bench judgment is also there. Every judgment said that particularly this mandatory nature 41, 42, subsection 1 provides a part that at night if they are to move, then authorization is to be obtained. And in a particular situation, if there is no such time to obtain authorization, then they can proceed, but report is to be sent within 72 hours. Another point, 50, that is also important for you. Most of the drug peddlers, they carry the drug in their body, isn't it? Most of the drug peddlers. So there is requirement of compliance of section 50. In Baldev Singh judgment, it is said that it is mandatory. That is also a constitutional bench judgment. It said that if you want to do the body search of an accused, you are to explain him about his right. You are to inform him about his right, that if he is interested, if he intends, he can seek the search, body search, in presence of a gazetted officer or in presence of a magistrate. That offer is to be given to him. That is to be explained his right. That is his right. That right is to be explained to him. Now he may choose that, no, I am not required. I do not require. I need not be taken to a magistrate or a gazetted officer. You can do the search. That is sufficient. But he is to be informed about his right. If that information was not given to the accused, then it is violation of mandatory provision and the case will fail. Whatever the proof is there, the case will fail. So when the law says, when the Supreme Court says that we are to proceed in a particular way, we are to proceed in that way. No way leave. Here Supreme Court said you are to, nothing more is required, you are to explain. And that explanation that I explained it, that is to be stated before the court. When you are adducing evidence, if you remain silent about that, then entire case will go ultimately. Here also Supreme Court discussed and said that it is mandatory in nature, and if there is any violation, the case will fail. Now, relating to seizure. Why I am discussing it? Because you also know that most of the cases failed because of the failure to comply the provisions of 41, 42, 43, 50 and regarding the seizure part. Now I don't know about Nagaland, but in Assam we have seen that most negligently the things are being done. Most negligently. And if someone, after 3 years, if someone comes with a plastic bag containing ganja without sealing, whether any court will accept that? It is not possible. Because law says that it is not we. We are none. It is the lawmakers and the government, they are deciding. Now you know that earlier there were 2 notifications which were being followed. One was by NCB in 1988, notification number 188, that was by NCB. Thereafter, Ministry of Finance, Government of India issued another notification, notification number 189. We were being followed everything regarding search, seizure, every direction were given there. Thereafter notification came in 2007, how inventory is to be prepared, and ultimately 2015 notification is there. All the notifications were issued by the Government of India. Government of India is the only government who can issue such notification. No state government can issue. It is the Government of India. But overriding all the earlier notifications, in 22, I have the notifications with me. If you have not got it, you can also download it from the website, central government website. It is finance notification. And that notification sent to every state by the Government of India that henceforth these are to be followed. Now what I will say from that notification. How the seizure is to be made, how the seizure is to be pegged, everything, every direction has been given there. Now if there is total violation of the same, or if it is not proved that we have complied, then how the case can come to an end in conviction? Now government said, first one is section 51. It says, CRPC says, apply in so far as they are inconsistent with the provisions of the Act to all searches and seizure. So section 100 of the CRPC says that it is to be done in presence of independent witnesses. Learned DGP pointed out a case at night. It was not possible to get any witness. That is a complete different situation. Court should believe. Even a police officer can be the witness. They can also be a trusted witness in such a situation when no other witness is available. Can be. Police personnel who accompanied the officer, they can also be a trusted witness if no other witness is available. But difference is that if you do the search and seizure in front of Dimapur railway station, always there remains people. So in these two situations are completely different. If in such a situation, if any seizure is made without the independent witnesses, then it will be seen differently. And even in such cases, suppose you have approached, law says what 100 says. Law says that you have to approach independent, respectable person of the locality. That is the law, 100. Now, respectable person, no respectable person is ready of that locality. You can take any witness from other place. That is also not ready to come. At least there must be note. There is a case diary. You are preparing. That case diary must reflect that I approached the other independent persons who were present there. Nobody agreed to be the witness. That approach must be there. Even you have power under section 160 of the CRPC to issue notice to a person to become witness. They cannot ignore. That will be violation. So you have all the powers. But complete different, a different terrain, no person is present at night. In such a situation, you overpowered or stopped a vehicle and recovered. How you will get witness? If you bring some witness there, then it will be not believable. So in such situation, it is to be believed that no witness was present. But it must be stated by you in your evidence. While giving oral evidence as well as in your note, in the case diary, must be supported in your note in the case diary that no person was present at that hours of the day, at that night. So situations are different, and basically you are to prove you are the person. Your note is there in the case diary, and the public prosecutor may also exhibit at that part of the note. Maybe. And you are to support it by your oral evidence. Otherwise, unless you prove it, nobody can go through the case diary. Court can go through. Court can view under 172. But unless you will point it out, unless you said it before the accused defense, they will not get the chance to cross-examine you on that point. So you are to prove that. Now here 22, if you read the 22 notifications, you will see that there are specific guidelines for search and seizure. Specific guidelines. How seizure is to be made, how it is to be sealed in presence of the witnesses. Now we have seen in Assam, there is a tendency that they are keeping it open and produce it to the officer in charge of the police station after 6-7 hours. Who will prove that during this period it has not been changed? I know that you have no interest to change, I know. But law knows nothing. Law is blindfolded. So you are to prove that. That's why law says that you are to seize, not only seize, you are to seal it on the spot. You are to take the signature of the independent witnesses over the sealed packet. You are to take the signature of the accused person over the sealed packet. Otherwise, if you give some other packets, who will believe? So these are the requirements. It is not we. It is the government of India who has fixed it. You read the 22 notification. It is 22 notification which gives the entire guidelines how you are to proceed regarding search and seizure. If more packets are there, how the things are to be packed. If small packets are there, how the things are to be packed. Every guideline. So you are to do accordingly as per the notification of the government. As per the notification of the government. Second, there is inventory, search, seizure list. Suppose 10 soap cases were recovered. Suppose 10 soap cases had items, isn't it? You are to weigh all the soap cases independently, not totally. All the soap cases are to be weighed independently, are to be packed independently, and the weight of that pack is to be written there. And while preparing the seizure list also, you are to give that this numbering, serial number A1, this much weight, A2, this much weight, A3, this much weight. You see, every MCB and other organizations, when they are doing, central government organization, they are doing in the same way. They are selling, packing all the items separately and give proper description. If you see the format of inventory, preparation of inventory, you will see that there is a column of description of the item. Now description, in case of soap item, description you can only give that this item, this weight. Now when the court will consider, I have seen that frankly speaking, our magistrates are also not doing, taking seriously the sampling process. No, not taking seriously. And if they take the seriously, we have to give the correctness of the inventory. We have to give certificate of correctness of our inventory. So if it doesn't include any description of the property, how we are giving the certificate of correctness? How we are giving? There must be, suppose medicine, I have seen a case, 100 bottles of phencyl cough syrup was recovered, 100 bottles, each bottle containing 100 milliliter. Now, how it is to be described? By batch number? It is easier to describe. Batch number is there, manufacturing date is there, name of the manufacturer is there. These things are to be given in the seizure list. This batch number, if there are 2-3 batches, 2-3 batch numbers are there, must be noted. Now if we do not, inventory also blank, search seizure list blank, suddenly we found that a sample was drawn, a sample and duplicate was drawn, their batch number and manufacturing date, everything is given. That report is given by the magistrate, it was taken in my presence. But if at the time of seizure, the batch numbers were not mentioned, it was not sealed, after one day produced before the magistrate, will certify that by this time it has not been changed. So the things are prepared in that way. You must give the details. Unless you give, for every batch there should be 2 duplicate samples. For every batch. Because these are sealed bottles. So if you take 2 bottles from a particular batch, that is sufficient. You can forensic can examine. But if there are 3-4 batches, who will say that other bottles will not contain water? So, you are to be cautious regarding, and the magistrates are also required to be cautious. I am saying so. Now, the problem will come more to you, both magistrate and the police officers. Under the BNSS, you know that every search is to be videographed. Every search is to be videographed. So, proof of videography you are to give, then the question of witness not supporting, etc. will not come. Because your videograph is there before the court, sealing, entire process of sealing, entire process of search, seizure, sealing, everything will be there. Now the court, they are also to do within 15 days. Not that not regarding NDPS alone, regarding all other seizure. The magistrate within 15 days, they are to prepare inventory. And they are to take photographs. If they want, they can also take videograph of the sampling process. So, that will be easier for tallying. That will be easier. Now, confusions will also be reduced, doubts will also be reduced, but both will be in problem. You must be conscious that we are doing in this way. Both.
So Moitra, just one question on this videography by the court as well as the investigators. If there are two videographs, one by the magistrate, one the police, the direction and the time may not match. So would it be?
No, that will not be matched.
So I was thinking, like, is it not possible that one videography is done and both keep a copy?
No, that is not possible because they will do the videograph at the time of seizure. At that time, magistrate will not be there. They will do the videograph on the spot. Magistrate will not be there. Magistrate
At the time of sampling, I'm saying.
At the time of sampling, it is
If one videography is done and both share the copy, would it not be easier rather than two separate videographs and then someone challenge that it is not?
They need not take the sample.
Yeah, okay.
They need not take the sample. They are to only sealing. Sealing process you are to complete. Then sampling is to be done in presence of the magistrate. In case of NDPS, I am saying. In other cases, BNSS says what is to be done. But in case of photography, etc., they are to certify. Earlier also they were required to certify the same, and they were required to certify the inventory, correctness of the inventory. Now also they are to do the same. In case of NDPS, no change has been made in NDPS because, but since seizure, that is under CRPC, so while doing the seizure, you must be conscious and do the, as CRPC says, it is to be, in that way it is to be done. So classification, weighing, packaging, everything is there. You please read the 22. In deposit of godowns, regularly we see that in Assam, Malkhana, it is deposited in Malkhana by the police officer concerned, but they do not take, when adducing evidence before the court, the Malkhana register is not produced. A copy of the Malkhana register is to be produced that I have deposited it at this time. Subsequently, you have brought it out for producing before the magistrate. That will also be noted in the Malkhana register. So, Malkhana in charge must be a witness. Along with the copy of the register, he is to prove the same. Or any other police officer who is known about the facts, he also can come and prove the Malkhana register to prove that it was deposited properly before at the Malkhana of the police station. Now regarding conscious possession, as Mr. Sharma has given a case that two persons were travelling in a auto rickshaw and some contraband were found. Yes, presumed that it is in their conscious possession. Two persons only travelling in a particular vehicle. The presumption will be that it was in their conscious possession, and case will be filed against both. So they have to explain. They have to explain. Now how they will explain? I am coming to culpable mental state of an accused. But conscious possession, if it is proved, conscious possession, suppose in a public vehicle, public bus, some articles were kept under the particular seat. No passenger said, accepted it. Generally what happens? The bus driver or conductor, they are made scapegoat, they are arrested. Now is it possible for the bus driver or the conductor to keep watch on each and every passenger? Is it possible? So that possession is there. It was found in the bus, but it is a public bus. Situation will be different if it is a public vehicle, private vehicle. If it is a private car and articles were found, first hand impression will be that they know it. Possession. Reasonable belief that it is a conscious possession of the person. Possession is okay. In the bus it was found, that is also okay. That is also okay. It is in the private car, it is also okay. But in the private car, that private person has some responsibility. So he cannot ignore that. Presumption will go that it is conscious possession. Suppose I have given my house in rent to some other person. Now what he is doing inside, I do not know. Now if he keeps some narcotic drugs, etc., etc., it is not possible on my part to visit every day. If I give it on rent, then I will be trespasser. Now in that case, if the possession is found, it will be possession of that person, not me, the tenant, not me. But the room is under me, under my control. Of course, it will be my possession, conscious possession. Now sometimes it may happen that I have information that police will come to my house. So to avoid impending search and seizure, I went to the house of my mother and kept the article there. Police chased there and recovered the same from there. Whose possession will be? My possession. So it is to be separated from conscious, unconscious possession. Basically the presumption, various decisions are there. Dharampal Singh is there, and other judgment, Union of India versus Nawaz Khan. This is most recent judgment. It has also discussed the earlier judgments of Dharampal Singh and others. There it says what should be the conscious possession. In Mohanlal also, that is another judgment, it says physical possession, custody, my control over the property, that is the conscious possession. Now quantity, again small, intermediate and commercial. You know, small quantity, Um, so these are the definitions, and the table is given behind the back from page number 175. The table is there, central government notification. So there it says what should be the small quantity, what should be the commercial quantity. And in between this small quantity and commercial, the definition says that means any quantity lesser than the quantity. Suppose the topmost, if you see the topmost one item, there is small quantity is 2. So it must be less than 2, 1.9 maybe, small quantity. From 2 onwards, up to the commercial quantity given, that will be intermediate. And the intermediate quantity is also there. Only the thing is that earlier there was a judgment, sometimes it is produced before the court. It is of 2008 judgment. That judgment said that if there is a mixture of narcotic drugs or psychotropic substance with other neutral substance, suppose along with heroin, some sugar of milk of homeopathic is mixed. Now when you will send it to FSL, the quantity of heroin will be shown lesser. So earlier judgment of 2008 was that only the contents which was found by the FSL, that will be considered. But the recent judgment, which is a 3-member bench judgment, Hira Singh and others versus Union of India, there it says that total quantity is to be taken, not the exact content. So earlier judgment has been overruled. Now this judgment will be followed. Now culpable mental state. So first of all, 35 and 54. The two provisions are there in the NDPS Act regarding culpable mental state. One says that in any prosecution for an offence under this Act, culpable mental state of the accused, the court shall presume, like 29 of the POCSO, a little lesser than POCSO, but here also said that if possession is found, first presumption will go that that person has the culpable mental state of dealing with the same, if it is found in their possession. Now 54 is also there, presumption from possession of illicit articles, almost same. So presumption of existence of such mental state is to be considered by the court. That is a direction to the court. 35 and 54. That first presumption, if it is found in possession, as in that case 2 persons were found in the auto rickshaw and recovered articles, presumption will go that both of them have culpable mental state, and court will presume that state. But defense, it is the defense who is to prove that he had no such mental state with respect to the act charged. So he is to prove that he had no such mental state. He is to go against that presumption. He is to prove that it was not correct. But in all cases of presumption of culpable mental state, foundational facts must be proved by the prosecution. And that foundational fact, in this particular case, Supreme Court also said that it is to be proved beyond all reasonable doubt. That is, the articles were recovered, illicit articles were recovered, contraband was recovered from that auto rickshaw. Okay, 2 persons were there, it was recovered from that auto rickshaw. That part is to be proved. That is the foundation of this case. And immediately if it is proved that it was recovered from their possession, if the prosecution is successful in proving the fact, then the burden will shift to the accused person to prove his innocence. They are to prove his innocence, that we had no such culpable mental state. But initial burden is always with the prosecution to prove the foundational fact of that particular case. And standard of proof will also be different. When the prosecution is to prove the foundational fact, it will be the beyond reasonable doubt. And when the accused person, it will be only preponderance. Regarding probation, probation 360 is not applicable. Section 33, it says, Section 360 CRPC or the Probation of Offenders Act is not applicable unless such person is below 18 years of age. So if he is a juvenile, then he may get the Probation of Offenders Act. And two other cases. In case of consumption, then only consumption, then Probation of Offenders Act, other cases not applicable. But there is another provision 39 that start with non-obstante clause. It again going against the earlier 33 provision. 39 says, if the accused person is an addict and if he is found guilty of an offence punishable under section 27, that is consumption, or if that addict is found guilty for offence relating to small quantity, but basis is addict. Only in case of addicted person it can be extended, and that too court must of the opinion, considering his age, character, antecedent, whether previously he was convicted or not, or physical or mental condition of the offender, if the court finds that it is expedient to do, and it itself says, notwithstanding anything contained in this law, that means section 33, in this particular law, it says that it is not applicable. In case of small quantity, it is not applicable. But here in 39 it says it is applicable, notwithstanding anything contained in this law. From time being in force, the court may, instead of sentencing him at once to an imprisonment with his consent, direct that he be released for undergoing medical treatment for detoxification or de-addiction from an hospital or an institution maintained or recognized by government. So he may be allowed to go on execution of a bond, like Probation of Offenders Act. Section 4 of the Probation of Offenders Act. They are to go on execution of a bond with or without surety. Here also he can be allowed to go on bond execution on bond, but the condition will be different. Condition will be that he will undergo medical treatment for detoxification or de-addiction. And bond must be entered with to appear and furnish. So there will be another condition in the bond that I will appear before this court within a year to submit a report regarding the result of the medical treatment. He will appear and submit that report. Now again, after going through the report, if the court considers that he should be released, he may be directed to be released after due admonition, again on entering into a bond. This time it may be extended for 3 years. Again he may be bound. He may be forced to bound for 3 years. That he will abstain from the commission of any offence under chapter 4 during such period not exceeding 3 years. He will not do any such offence like section 4 bond of the Probation of Offenders Act. So he is to execute the bond, or on his failure so to abstain, again he will be brought before the court and will give the sentence. So other things you know, and not also in today's topics. But as I said, it is the question of evidence. Court will consider only the evidence. Whatever may be, we cannot go beyond that. Even if the trail is too big, we have to prove that trail. Now, in a recent case, I have seen in Assam, I am not naming the district because I have gone through the record, it is still pending. 2 trucks were coming from Mon, going there. They stopped in a petrol pump. One small van also went there. It was around 1:32 p.m. at night, 2 a.m. at night. Two trucks and one small vehicle. Vehicle went from Guwahati side. Those 2 trucks were coming from Mon. Now, the case of the police patrolling party is that they noticed that drugs were being transacted in between the auto rickshaw and that truck. Police recovered the same. Thereafter informed police station. Empowered officer came there, did everything. That is okay. The 2-3 questions were there. First of all, a patrolling party, the GD entry also shows that the patrolling party recovered the drug. And on their information, the search and seizing officer went there. Now the question is, nobody of that patrolling party were made any witness. Nobody. They were the first person to reach there and to intercept that vehicle. So they were the best witnesses in this, best probable witnesses in that particular case. None, all of them were police personnel. None of them were made witness. Secondly, the GD entry shows that they recovered the item. But the search and seizing officer in his FIR as well as in his evidence said that after going there, he made search in the auto rickshaw and recovered a bundle of all soap cases. Recovered those soap cases, about 200 or 300 in numbers, from that auto rickshaw. Is it possible? Once police patrolling party recovered it, how it again went to the auto rickshaw? Second, mobile phones of all the 3 persons were seized. But neither the search and seizing officer nor the investigating officer ever tried to collect the CDR. Whether there was any communication in between these two parties. One came from Guwahati, one came from Mon. Two vehicles came from Mon, one came from Guwahati. So there must be communication. Communication by any means. So when the mobile phones, for what purpose it was seized? Only to get it damaged in the police malkhana. Or for what? No CDR was collected, nothing was done. So this type of investigation, do you believe? Nowadays you can't consider even without electronic evidence. You can't consider any case without electronic evidence. I agree to the learned DGP. Nowadays it is not possible. So to connect the trail, you have to first found out that what was happened, how it was communicated in between, how both parties came to the same petrol pump. You have to prove that. But no attempt was even made. No attempt. Such seizure witnesses were there, so many seizure witnesses were there. All of them were village defense party. They were giving night patrolling duty also. Rightly they were made witness. And none put any signature in the seized articles. No seal. Seized articles were never sealed. Not put any signature. Seizure list not prepared properly. Inventory not prepared properly. How you can convict a person? Because the person will be convicted for 10 to 20 years. It may be extended up to 20. But to give such stringent punishment, the technicalities are to be followed. I am not saying that you have to do something which is unnatural. But what is in your hand, you can do. You can seal the packets. You can take the signature of your own village defense party. You have not done. The place, the petrol pump where the truck and auto rickshaw were found, CCTV was there. The police was so negligent, they even didn't try to collect the CCTV footage. It is not that in road, it was inside petrol pump. So how you will convict a person? Convict 3 persons practically. So everything, it is not that we are willfully doing everything. We also want to, because our Supreme Court also said that a murderer kills one, but this menace of drug kills thousands of people, so they are to be treated also harshly. We agree regarding bail matters, Supreme Court said it. But for giving conviction, final conviction, there must be at least some proof, some believable facts, trustworthy facts to give conviction. Otherwise we will give conviction, tomorrow he will come out from the High Court, isn't it? High Court will see only the evidence, will not go through anything. So tomorrow will he come out. So please do whatever in your own hands. It is good that all the stakeholders are present here. At the same time, public prosecutors are also do some more. What we have seen, I was also district judge for long. I have seen that after 3-4 years, nobody can have such photogenic memory. I did so many commissions. I went there to adduce evidence. So many inspections, 164 statement, confession, recording of confession. I used to adduce evidence, but before adducing evidence, I used to go through the record. Because nothing remains in my mind. It is difficult to expect that general people, a common man, will remember everything. He will have photogenic memory after 3-4 years even. Only a witness who is made witness, cooked up witness, they will keep it remembered. But in other cases, it is the duty of the public prosecutor also. I know that public prosecutors are the officers of the court. It is not their duty to look at the conviction of an accused. It is their duty to prove the truth, put the truth before the court. It is the duty of the public prosecutor. It is not their duty to seek conviction in all the cases. But at the same time, when a person comes after 3-4 years to adduce evidence before the court, at least they are to show their previous 161 statement. Otherwise, how they can remember everything? That part is to be done by the public prosecutors also. I am saying also our officers to be alive about the situation. But outside evidence, we can't do anything. But regarding bail matters, yes, it is stringent provision and it is to be followed. It is to be followed. Unless it is a small quantity, if it is a commercial quantity, then stringency of the provision is to be followed. But regarding other facts, I don't think that everything is to be done. Another thing, sometimes we have seen consumption of narcotic. You are giving cases under 27. But while examining the accused person by the doctor, there is no such report. He has consumed drug. That report must be there. So please look also that part. And thank you for giving a patient hearing. And if there is any question,
Sir,
we are all here.
Sir.
Director sir is also here. Director sir did many cases, disposed of many NDPS cases, good knowledge in NDPS Act also. So, Lordship is also here. If you have any question, we can give. We will try to give the answer.
Sir, kindly highlight again about the sampling and sample being sent to the FSL, the sequences.
No, you see, sample is to be taken by the court. Now, Mohanlal judgment, section 52A. Court will take the sample. But at the time of taking sample, court is to give the correctness of the inventory. If the inventory doesn't give any detail, then it must be noted, or must call the officer in charge to make it correct, that inventory. The officer, our officer cannot correct the inventory prepared by the officer in charge, isn't it? Now, after that, it is to be written that it is done here, because photograph will be there. Photograph shows that it is all in plastic bag, unsealed condition. Now, you know what will happen ultimately. Ultimately, after one day, if it is produced, every trail is to be proved. It is not that a sample is taken today, tomorrow is to be sent. It is not that. Because the sealed envelope will have the signature of the court also. It cannot be tampered. But before taking the sample, court is also to see that whether it is reliable or not. But they can't do anything. They have to take the sample. But the order will reflect produced before me in unsealed condition. What the court will do? Because the recent notification
Sir.
specifically said it is.
So regarding certification, just adding to sir's question, if it comes in an unsealed manner and they paid for certification, considering that it's unsealed and we cannot verify whether it is what it was.
No, you need not do that. You need not do that. If it is produced in unsealed condition, you will take the photographs, isn't it? So you have to keep the correctness of the photographs. The photographs will show that it is unsealed. Thereafter the trial judge will consider whether he will believe it or not. At best, you can, while you are writing the order, you can write that produced in an unsealed condition.
Do we give certification then, sir? So would we still
You need not
give certification?
ask for sealing, because in your presence it will be sealed again.
Yes, no, sir. So because the application prior to the notification of 2022, 2015 had the prescribed format of how the inventory is supposed to be done and the certification also. So if it's an unsealed manner and we cannot verify and the details also are not written in the inventory, if at all, then do we as magistrates give certification or not, sir?
No. Whatever you will get, you will give that certificate. You cannot deny that. It has been produced in an unsealed condition. You will take photograph and you will give correctness of the photograph, isn't it? You will give certificate of correctness of the photograph. That itself will show that it is unsealed. And the trial court will decide whether the trial court will believe or not. You are not the trial court, isn't it? So you need not write, but inventory, if it is incomplete, you can call the officer in charge to correct it.
The sample which is drawn, sometimes there used to be a delay of months, even more. Please elaborate.
If there is a delay, you see, the sample was taken, sample was sealed in presence of the magistrate. Whether you will believe your, disbelieve your magistrate? No. With the sealing, a signature will be there of the magistrate on the envelope, isn't it? So, if it is sent after 1 year also, I am saying, then also the same thing will be there. Only the question, there should be instruction to the FSL that they are to note in their report whether it is with the seal and signature of the magistrate, whether it is sealed and whether there was signature of the magistrate. That should be noted by them, but most negligently. That's why I said one of the armies absent, because you will see that somehow they prepared the report only. And if you ask questions to them, they will give vague reply that I have not noted. Sometimes even, I don't know, sometimes even they are managed or not. But reports are not satisfactory at all. In the report they should say that it is under signature of the SP, it has come to us. And the envelope Before opening the envelope, we check the envelope, there is the signature. May not be the officer, FSL knows the signature of a particular officer, but the signature and seal and signature of all the magistrates are to be given at the connecting point, so that it cannot be opened. Then if they question it, that will fail. If they question that after 1 month, what happens? My seal is there. My seal was there. Isn't it? So after 1 month, if it is sent, if it is unusable, then it is different. But if can be used, what is the harm? His or her signature will be there. Our officer's signature will be there at the connecting point. So it cannot be tampered with. Isn't it?
Sir, can I also take some time?
Yes, yes.
So, sorry interrupting you.
Yes, yes.
We have overshoot the time. I'm a psychiatrist, and this NDPS thing includes me also. The reason why I'm here, most of my doctor colleagues have left, and I'm in District Hospital Dimapur. In the NDPS Act, there needs to be a NDPS consultative committee. That must be there in the center, where National Fund for Control of Drug Abuse they handle. And when we talk about this, it means activities related with supply reduction, demand reduction, and harm reduction. Harm reduction means till down the detox centers, detoxification centers. Our DGP is not here. I thought he would be able to throw some light on this. I was wondering whether we have that kind of a subcommittee in our Nagaland state. And if so, what are they doing? How much, what all activities they are doing? That is one thing I wanted to know. And if anyone here knows about it, it will be good for me to understand better. That is one. Number two, the drug addicts are released on certain conditions. One condition is they are released if they opt to go for treatment. Another condition is if they are not likely to commit the offense again. That was another point that was mentioned. Now here, we all know that the drug addict, they go to rehab, come out, relapse, it goes on and on. So how long can it continue? He will decide to go for treatment. So he is released from the custody. He goes to a rehab, comes out, again he is caught. How many times that can happen? That is the problem. Now if some modifications can be there, of course we cannot do anything about the act that has been passed by the central government. If they are caught, I considered, I'm a psychiatrist, we should treat them, all those I know. But if they are caught, I take it as a blessing for them. They will go through the process of natural detoxification. They will get an opportunity to lead a drug-free life for some time in the jail. And they will get time to contemplate on their situation, self-analysis, and they may come out a better person. So I don't know how long that can continue.
No. You will see there are 2 stages. First, the court can release them on their bond for medical treatment. Bond to be given for 1 year only to give the report of their medical treatment. After going through the report, if the court considers that yes, now he is completely okay,
Yeah.
then court can release him on admonition, and along with it, the accused person may be asked to give a bond that he will not do the commission, not for the first time. During the first stage, he will be sent only for medical treatment. He will be released only for medical treatment. After treatment, when he will come out fully cured, after going through the report, he may be released by the court. That he has been cured, now
Yeah.
he is released.
Okay, okay. And another point is presumption of culpable mental state. Now, the procedure involved. Person is caught with some drugs in his pocket, and he is acting as if he is mentally unstable. Now he needs to be sent to a psychiatrist for assessment, and the person will come to me. I am the only psychiatrist in Dimapur, so the person will come to me. Now the procedures involved is what all papers that person should be bringing along to me so that I do the assessment. That is one thing I want to know. I'll just highlight my points first. And then some suggestions. OST medicine, that is buprenorphine. And buprenorphine is also an opioid. In relation to why the OST program, that will take 1 hour. I will not go into that. But drug use in OST is also an opioid, like heroin only, buprenorphine. Now, I don't know, drug addicts are caught in the street, and they may be having buprenorphine tablets in their pocket. This has been provided by the OST center, and if they are released. And that is something that should not be happening. From OST center, I want this as an information for everyone. OST centers, it is given on daily basis. They are not given takeaway, except on few humanitarian ground. Father died, mother died, for 1 week, medicine is given. Otherwise, medicine is not, takeaway medicines are not given. And then buprenorphine medicine is available in the black market. That must have leaked out from some OST centers. Otherwise, it is not available in any of the pharmacies or wholesalers. It directly comes to the medical department, from the medical department to the OST center. And if it is available in the black market, I want the authority responsible. If you get someone with OST medicines in their pocket, try to trace and find out from which OST center it has leaked out. And if that information can be passed on to the medical department, stringent action can be taken against the caregivers of those OST centers. That is one thing I wanted to convey to everyone. Another thing is the so-called sunflower, which is popular today, whether our Home Department, Police Department had done an analysis on the content. It is not, it has heroin family also, but along with heroin family, I believe, according to the withdrawal symptom that I see, not only heroin, but other substances are also there. Because the duration of action of sunflower is 8 to 10 hours, 10 withdrawal symptom. But the brown sugar, it is about 6 hours only, 10 withdrawal symptom. That implies that not only heroin family, but some other substances are also mixed. And whether our police department has sent this sunflower for some chemical analysis and get to know as to what all substances are there in the sunflower. And also the purity of the heroin family, at what level it is, 30%, 40%. So if whether that has been done or not, if not done, I think that is something which would be very important.
This question has been answered by the Supreme Court. Supreme Court said nowadays only the intermixture will be considered, not the contents.
Okay, but when it comes to treatment,
No.
the addiction,
For treatment,
we require that.
No. For treatment, that is completely different.
Without
That
knowing
will
the
be-
content, it becomes
that will
difficult to
be-
treat them.
That will be decided by the state government whether it will be released for treatment or not. But otherwise, if it is heroin mixed with other items, then also the total quantity is to be considered. After this judgment, we do not have anything in our hands.
I am suggesting this because we are not in a position to send, I have never seen sunflower. We don't see it. Only the police personnel who catches the drug addicted get to see. So the sunflower powder is with them, it is not with us. If it can be sent and we get to know the content, that will go a long way in helping us treat them better. in the detoxification process.
That is, you have to discuss with the health department. We cannot say anything.
And another medicine I want to highlight to all the police personnel especially.
Yes, sir, I think the question, I think it is not, it is out of the topic here. Sir's topic is a very specific.
Yeah,
So
okay.
I think that is the purview of the state government. I wish all the
Yeah.
commissioner secretaries and DGPs were still here, but
Yeah.
since they have left,
They have left.
let our speaker finish what he is supposed to say, since we are running shortage of time at the same
Yeah,
time.
yeah.
We can have a discussion in the other platform, as in when required.
Yes.
Any other question?
The procedure I was asking.
Regarding procedure also, how the de-addiction center?
No. Suspected mental problem, a drug addict got caught, and he is being suspected as having some mental problem. What is the procedure involved
No,
in such a way that he comes to psychiatrist?
Yes, yes. In all cases of suspected mental patient,